All right, we're back on the record. As indicated prior, Mr. Gould, on behalf of his client, filed a motion regarding custody, parenting time, and support. Also, a show cause was filed. The law is somewhat unclear, I guess, on the necessity for his permission to change the domicile of the child when one parent has sole legal custody. That's certainly true that permission is not required to move more than 100 miles in Michigan, which normally it is required if one party wants to change the child's legal residence with joint legal custody. Case law is a little bit less clear on whether that same permission is needed or not to move the domicile out of state. I guess based on what I'm about to order as far as custody is concerned, I don't know that the determination on the show cause is absolutely necessary. So I'm going to dismiss the show cause. As far as custody goes, the way a custody motion works is that the motion is filed, court has to make an initial determination on whether there's a change in circumstances or proper cause to consider the motion. And the judge heard at least some initial statements on December 12th regarding the motion. And in setting it for further proceedings, I assume that she was of the opinion that there was a change in circumstances or proper cause to consider the motion. Whether that was specifically articulated or not, I don't know. But at this point, I will make a finding that there is proper cause to consider the motion because the child's not living with either parent at this time. So that then shifts the focus to whether there's an established custodial environment with either parent, and be determined at this time that there really isn't. The child has lived here and there for, it sounds like, a lot of her life. She lived up until 2018 or 2016, the case was filed, and there was an order entered as we've gone over through testimony in 2017 and then in 2018, granting custody and parenting time. But then the parties resided together under some arrangement for the better part of a couple of years over the next three, from 2018 to 2021, give or take. Then it sounds like mom moved out of the dad's house, or the dad, his house with his parents, and lived on her own for some period of time. But then the child went back and lived with dad from sometime around a year ago until around the end of the school year. Dates are somewhat foggy because the parties are not in agreement on those dates, but for some period of time anyway. And then the child went back with mom, it sounds like, for the summer, and maybe a few weeks at the beginning of the school year. But then the child's with the grandmother, and really a custodial environment has to be established over time. And the child hasn't had a significant length of time with anybody really to establish a custodial environment at this point. I guess I will state that probably the most stability that she's had, it sounds like, for those 6 months or so with Mr. Hughes over the last few years. So as far as the two parents are concerned, I'm not sure about the situation with grandma right now. Maybe it may be just fine. However, as I've indicated, this is not decided between a third party and a parent. This is decided between the parents. And I don't even get to the point where I can consider third parties for custody, as I've stated, unless either parent is determined to be incapable of or unwilling to raise a child, or both parents are considered to be unfit. And I'm not making that finding at this time. So at this point, the child custody factors would be analyzed by preponderance of evidence. The testimony, and Ms. Williams was given ample opportunity to present any testimony she wanted. Her testimony didn't necessarily consist of a lot of things that could be plugged into the 12 child custody factors. Mr. Hughes did. So the first factor comes down to essentially a bond between the parent and the child, whether who the child's bonded with, who the child goes to with problems, does a parent relate to a child? Things like that. Specifically, the law says the love, affection, and other emotional ties existing between the parties involved and the child. And Mr. Hughes testified about his relationship with the child, the fact that they do fun things together. They go to, they play outside, they ride the quad, they go to the trampoline park, they go on trips together, they go to the lake, he reads books to her, he prepares cereal and school lunch, the lunches at school, but dinner's prepared for her. And I would find him in favor on that factor. The second is the capacity and disposition of the parties involved to give a child love, affection, and guidance, and continue raising the child in the child's original and to continue educating the child. It appears that I don't know where the child really went to school from for the fall of 21 or the fall of 22 up until she moved in with her grandmother, but it sounds like he provided schooling for the child for the second semester anyway of the last school year. When the child was residing with him, it sounds like there was some issue with the threat. It sounds like that was dealt with. He noted some behavior issues, so he made himself a presence in the child's school. He said that improved things. He said at home she was just fine. And for those reasons, I would find him in favor on factor 2. Factor 3 is the capacity and disposition of the parties to provide the child with food, clothing, medical care, and other care recognized under the laws of the state. Mr. Hughes testified that the child has food and clothing in his care, and those necessities aren't in question. And I would find him in favor on that factor. The next factor is the length of time the child has lived in a stable, satisfactory environment. As I've indicated, the child appears to have moved around a fair amount, and hopefully that's not going to become a problem as time goes on or in the future. It sounds like Dad was really ready, willing, and able a year ago to provide care for the child on an extended basis. It sounds like it doesn't sound like the mom, Ms. Williams, is really capable of raising the child on a consistent basis. Child was with both of them, then with mom for a short period of time, then with Dad for 4 or 5, 6 months, then with mom for the summer, and now with grandma for what was presumed was going to be the school year. So it doesn't sound like Ms. Williams really has the either the capability or the interest to provide long-term care for this child, and I find in favor of the father on that factor. Fifth factor is the permanence of a family unit in either home. It sounds like Ms. Williams lives with a friend and Mr. Hughes lives with his girlfriend. So that factor is not really relevant, I guess. The moral fitness of the parties involved, I didn't hear anything that would cause me to believe that either of them were immoral or that they had a criminal record or abuse neglect record that would affect their ability to parent. So I wouldn't consider that factor. Mental and physical health of the parties involved. I heard 3 different reasons why Ms. Williams was not able to raise the child on a steady and consistent basis. I heard she works too much, that the child needed an attitude adjustment, and that she had health issues. So that would certainly impact that factor. And really her mental health, I guess. I don't know. I'm not 100% sure what's going on there. Her behavior on the record was a little bit out of the ordinary, and her testimony or statements consisted mostly of yelling and not really just calmly and coolly presenting evidence. And so I'm not really 100% sure what's going on there, but certainly it appears that that there might be some issues going on, and I would find in favor of Mr. Hughes on that factor. Child's homeschool and community record. I didn't hear a whole lot about the home school or community record from Ms. Williams. Mr. Hughes, however, testified that the child did well in school when with him. She was recommended to be passed on to the next grade. I guess it would have been nice to see some attendance records for that period of time to establish really the exact date she was in his care. I didn't have that to consider, but I guess she was in kindergarten then and she's in 1st grade now, so it must have been a recommendation that she move on. So I'd find in favor of Mr. Hughes on that factor. Next factor is the child's preference, and I don't know what the child would tell me. She might say she wants to live with grandma. She might say mom. She might say dad. Um, really, it's not going to be relevant at this point. And I don't like to say that because I think kids should have a chance to have some input in these things, even though it's not usually enough to overcome substantial amounts of evidence to the contrary. Um, but I guess I'm assuming that the only real options here are between Ms. Ratton and Mr. Hughes, and that Ms. Williams' house isn't really an option. So, you know, that for the reasons I've stated regarding third-party custody, I guess the child's preference or in-camera child interview isn't really necessary. So that's not going to be considered at this point. The next factor is it's a long one, but it comes down to the ability of the parents to co-parent. And it sounds like when left to their own devices, they co-parent okay. I mean, mom was having an issue. She needed to lean on dad for a place to live for a while. And he moved her in. It's his parents' house, but he moved her in for a couple different periods of time, it sounds like. And then mom needed help with the child at the beginning of last year. And dad stepped up and he took the child under his wing and provided care for her for the rest of the school year. And then when mom wanted her back, he gave her back. And they saw the child for whatever periods of time in the meantime. And the child was with the other parent. So it sounds like they can co-parent when they have specific operating instructions, maybe. But then this issue with the child being sent off to Florida through a monkey wrench and things, and so I'll find the parties equal on that factor. The next factor was domestic violence. It didn't appear there was none testified to anyway, so that factor wouldn't be considered. Any other factor that the court feels is relevant, certainly the child being moved off to live in Florida is relevant with a third party over the objection of the parent who was the father. He has not agreed to that. He's not been found to be unfit, so his opinion has to be considered. And an order can't be entered contrary to that opinion unless the court were to make that unfitness finding over his objection. And I've said 3 times now, I think I'm not making that finding. So at this point, Mr. Hughes will be granted sole physical custody of the child. The parties will be granted joint legal custody of the child. The child will be returned back to Michigan and in Mr. Hughes' care. Ms. Williams, to the extent she's able, will be afforded reasonable parenting time pursuant to front of the court reasonable parenting time policy. And I need some more information to determine a child support obligation here. So you said you make 17 what per hour?
Like 1767, I want to say.
All right, you work 40 hours a week?
Yes.
Do you have any other minor children besides this child?
Yes, I have a son that lives in the UP.
How old is he?
7.
All right, he's your kid?
Yes.
Okay. And so if mom has reasonable parenting time, you'd have 263 overnight. She would have 102. Is there, let's see, who's typically claimed this child for a dependent on tax time?
I have, but I've always given Kristen most of that money for having me claim her.
No, you do not. Don't even lie.
I'm not.
Well, if an order doesn't determine it, then it would be the party who has the child the majority of the time would be the party who would claim the child. So I'm going to put that in Dad's column. You had the child for 6 months of last year.
No, my mom
Got
should claim
custody
her.
going forward.
No, my mom should claim her.
No, your mom's not going to claim her. Mr. Hughes is going to claim her. He's the parent. He had the child for the first 5-6 months of the year.
No, he didn't.
And you had the child for some period of time.
You listen.
Your Honor, could I say something just real quick? My phone's gonna die. I just need real quick, just my phone's about to die. Is there any way we can wait till the end of the school year to send her back to Michigan? So she doesn't have to change schools again?
No, she shouldn't have been, it shouldn't have been changed down there in the first place. I guess if Mr. Hughes agrees to that, that's fine, but I'm getting the idea that he doesn't, so that's.
And he better figure out a way to bring her home.
Ma'am, how much do you make in your position at your work?
$13.50.
Where do you work?
Reed City, Big Rapids Fields.
Oh, that's good. How many hours a week?
Between 32 and 40.
And do you have any, you have minor children. How many minor children do you have in addition to this child?
3.
3 total or 3 more?
3 more.
Okay. And do you claim those children for tax purposes?
We split years between my younger 2, and then my son's dad claims him.
And sir, do you claim your son or not?
No, his mom does.
He doesn't even see his son.
How's the child? Either of you have health insurance on the child?
He has Medicaid.
Florida Medicaid at the moment.
Yeah. Big Rapids Fields doesn't offer health insurance, ma'am?
Nope.
Sir, does Cedar Springs Public Schools, they must offer health insurance.
I don't know what their health insurance is quite yet. I'm still working on that.
Let's see. I think that's all I need. Let me compute child support real quick.
Great, I'm gonna be even more dead. Never be able to do anything anymore.
Kelly?
Yes.
Oh, I was gonna say it might save your battery if you shut your video off and just leave your audio on.
Yeah, I just turned my, yeah.
Oh, but now you're muted. So
Oh, there. Now I'm unmuted. I just don't, this is my first Zoom. I don't know. I even know how this works.
oh, okay. I just thought it might save your battery if you had the video off.
Yeah, I turned my battery saver on, but yeah, it's really about to die.
There will be all of the court order will be put in writing, mailed out to Chris. So you'll know exactly what it is.
Okay. I just want to make this easy on Emma.
All right, utilizing the incomes provided in the overnights, effective January first, Ms. Williams would be ordered to pay $213 a month support, 15 ordinary medical, total of $228 per month. And Mr. Hughes' support would be set to zero, obviously, at that time. He'd be the recipient of support. Child's to be turned over to Mr. Hughes within 7 days. Anything
He's
further for
gonna
today?
have to. He's
What's
gonna
that?
have to find a way to come get her, Your Honor. My husband and I both work full time. I've got no way to bring her back.
Are you able to meet halfway?
It would depend on the time. I've got, I get like 3 days off and then I go back to another job.
A weekend, my client's available to drive on the weekend.
My weekends are when I work. I work for a food vendor. We work at art festivals.
Your husband as well?
I guess we can try to figure something out. Like I said, my battery is really gonna die. You guys are probably gonna lose me any second. But go ahead, Your Honor. I'm sorry. I didn't mean to interrupt. I just don't have a
Well-
way to bring her totally back to Michigan.
I get that. I mean, a situation has been created here against Mr. Hughes' interest. And to require him to drop everything to travel to Florida to pick up a child that shouldn't have been there in the first place.
He
At
did.
least not for this long. He addressed this right off the bat. He filed his first paperwork back in the beginning of November, as soon as this whole deal went down. He should have been the one who was asked.
But
to
he
get
didn't
the children.
contact his daughter. He may have contacted the courts, but at that time he was not in contact with his daughter.
Okay.
But
well,
regardless, I'm sorry.
Yeah.
You,
So whatever's easiest on him, Mr. Hughes, what's the quickest you can, maybe meet halfway to pick the child up or go get the child?
Meet halfway tomorrow.
I can't do it tomorrow.
It's gotta be a weekend because I work Monday through Friday.
Well, I'm at work right now until Monday.
I mean, I can talk to my boss and see if I can take a couple days off to drive halfway down there, but that's me losing money.
Yeah, I get that. Ms. Williams, what about you? I mean, you're kind of responsible for creating this whole situation. What can you do to help get the child back sooner rather than later?
I have no way to go get her. My car's not gonna make it to Florida. There's no way.
Your Honor, we were brainstorming, maybe,
And
my
she's
client
not
is willing to
flying.
fly down to
She's-
Florida and
she's-
pick up Emma and bring back, but there's the cost of the plane ticket is the,
She's not flying from Florida back home by herself. No.
right,
He said
I
he would- he
suggested.
said he
that
would
Mr.
fly
Hughes
down there.
fly
And
pick
get
her
it.
up.
Well, I can't upfront money for him to fly to Florida because I pay $325 in child support on my son, and now you want me to pay him $215 a month? Like, that leaves me with nothing to support my other children at all.
Mhm.
But nobody cares that, oh,
All right, so Mr. Hughes is gonna fly down and get the child. Ms. Ratton, he'll let you know when he's gonna be there and what time to have the child available for him. Ms. Williams will repay the amount that it costs for those flights within 6 months.
I don't think she should have to pay it all.
no, I'm not.
Okay, well, if a contempt proceeding is filed as a result of that, then we'll have a hearing on that. But at this point, that would be the order. Is there anything further for today?
Just to be clear, Your Honor, when you said that dad can claim Emma on the 2022 taxes, is that going to be written in the order?
Yes.
And I'm not terribly familiar with the Nuevo schedule. When would mother's first weekend visit be?
It would be this weekend, so more than likely 2 weeks from now, every other weekend.
All right, I don't have any other questions. Thank you.
All right, we're all set then. You get orders in the mail within a couple of days.